Good morning, ladies and gentlemen. Title of my talk this morning is Environmental Claims and Insolvency, Two Divergent Regimes. And I chose the title on the basis that it seems to me that after 20 or perhaps 25 years of the development of a huge body of environmental law and licensing systems, that we are no nearer really a resolution of what I call the interface between environmental law and corporate law stroke insolvency law. And I guess one way of approaching this topic is to say that an important measure of the value placed on the environment is how, if you like, the law treats environmental claims and cleanups in the context of business failure, in the context of insolvent businesses. And the questions that arise really are ones like, are environmental claims given any particular status or priority? Can environmental regulatory authorities be heard in winding up proceedings? And to the extent that insolvency practitioners like liquidators and receivers can incur personal liability in the discharge of their duty, does that extend to liability for environmental damage on their watch, so to speak? So these questions will increasingly arise in straitened economic times where perhaps environmental management systems for some businesses may become unaffordable luxuries, and where historically lax environmental standards will become apparent in perhaps the environmental exit audit that could follow a closure through enforced financial distress. So I'm really going to look at the topic from three perspectives. Firstly, from the environmental law perspective, to what extent does environmental law and licensing systems, to what extent do they, if you like, anticipate business failure? Secondly, from the insolvency law perspective, to what extent or how or to what, whether or to what extent do they, if you like, do they recognise or do they accommodate environmental claims like anticipated cleanup or contingent environmental liabilities of that nature? And then thirdly, looking at the environmental law, insolvency law interface through a broader lens by looking at the state of the law in relation to things like directors' liability, if you like, personal liability of directors, and lenders' liability and the position of receivers and mortgagees in possession. I'm just going to go ahead to the second of those. Jonathan mentioned the Irish ISPAT decision, and I think it's probably one of the best case studies for this particular interface that we can focus on. So many of you will be aware of the fact that the background to the case of the Minister for the Environment and others v. Irish ISPAT Limited in voluntary liquidation, which was decided in 2005, was really the fact that the original company, the state-owned Irish Steel, had operated the steel plant on Holbolan Island since the 1930s, during which time significant pollution arose. And moving forward to 1996, the state sold the company and the business, which had not then yet been within the IPC licensing regime, to ISPAT Mexicana, part of the global ISPAT group of steel manufacturers, and in tandem with that, to, if you like, allow the incoming company to occupy the site, made foreshore and property leases to the purchaser. And then there followed 5 years up to 2001 of very unsuccessful trading by what became Irish ISPAT Limited, a private company. And two things converged in June of 2001. One was the grant of the IPC license by the EPA to the company. The rollout, if you like, to steel manufacturing had taken effect at that point. The company had made its application, had been granted the license with RMP, we'll encounter those terms later, residual management plan, environmental liability risk assessment, and financial provision conditions as part of the license. But the company had been trading very unsuccessfully, and in effect, on the very same day as the company was granted its IPC license, 22nd of June 2001, the company had gone into voluntary liquidation. The creditors' meeting had been called. The liquidation took some time, and moving into 2002, the liquidator, relying really or drawing on a UK case in re Celtic Extraction from 1999, applied to disclaim the IPC licence as what's called onerous property for the purpose of Section 290 of the Companies Act, which is a mechanism allowing the a liquidator to, in the interest of an orderly, if you like, streamlining of the valuable assets, to disclaim onerous property, and those proceedings, while they were waiting for hearing, in 2003, the state brought, if you like, cross proceedings under Section 58 of the Waste Management Act of 1996, which Sections 57 and 58 allow a party to apply to the High Court to get the court to order a holder, or in the case of Section 58, a past holder of waste, to discontinue the holding of the waste and to make related orders for clean-up and remediation and mitigation of the damage, and so on. So both sets of proceedings came on for hearing and were heard consecutively in 2003, late 2003. And really, getting back to the Section, or just dealing first with the Section 58 proceedings, the issues, if you like, and the findings in those particular proceedings, a critical issue was whether, for the purpose of Section 58, the company or the liquidator could be deemed to be a holder of the waste. And in that regard, the position was complicated somewhat, and by the fact that, you recall I mentioned the making of foreshore leases and property leases to the private company. Those leases contained, or the property leases contained, 7-year break clauses entitling the occupant to get out after the first 7 years. And again, that 7-year period terminated also in June, or about there, certainly later in 2003. The liquidator activated the break clauses, and ultimately that's what, if you like, led the High Court to find that the company, at least, couldn't be deemed to be a holder of the waste because it wasn't in control of the premises for that purpose. Moving towards, if you like, the interface between waste principles, if you like, and the fact that a holder of waste may have a liability in respect of past holding of waste or a clean-up obligation, and company law principles, the state highlighted the fact that there was a large degree of intra-group or intra-company loans made from the parent company, if you like, to Irish ISPAT Limited. And in that regard, the message really from the state was these weren't real debts for the purpose of the insolvency at all. They could be disregarded. They were intra-group, they were intra-company, and that the money that would be otherwise applied by the liquidator in repaying those loans to the parent company would be far better applied in cleaning up the site. But if you like, in the first statement by the High Court Judge Carroll, to the effect that, you know, if you like, not undermining the integrity of insolvency law principles, she said that there was absolutely no basis to touch the status of the intra-group loans in that regard, and that, if you like, environmental law in that vague general way did nothing to displace the fact that there were debts properly provable in the liquidation. Because Section 58, if you like, covers not just holding of waste, it covers past holding of waste as well. Section 58 continued to be relevant for the purpose of the Section 58 proceedings and the orders sought. And so Section 58, ultimately the orders made on the basis of a residual discretion that the court enjoys. And in relation to exercising that residual discretion, ultimately the court refused to order the clean-up of the site by the company or the liquidator. And critical to its finding in that regard was the timing of the issuing of the IPC licence. The fact that it had literally been issued after production had ceased was influential as far as the judge is concerned. In the 5-year period that the company privately had generated waste on site, if you like, the court felt that that was insignificant as regards the 50 or 60-year period that the state had generated all of this waste. And And that, to my mind, is somewhat questionable on the basis that even in that 5-year period, it coincided with a huge ramp-up of production. No less than 100,000 tonnes of hazardous waste had been left on the site by Irish Ispat Limited in the 5 years that they were trading unsuccessfully on the site. And its environmental compliance record, in fact, deteriorated considerably in that same 5-year period. As regards relying on the timing of the IPC licence issuance in relation to refusing a Section 58 order, that is also, again to my mind at least, somewhat questionable in the sense that at the very outset of the proceedings, the High Court judge had said that, if you like, she had separated out the IPC licence issue that we'll be coming to in a moment from the Section 58 issue, by saying that Section 58 had really nothing to do at one level with an IPC licence. The IPC licence was a licensing regime. Section 58 was a standalone environmental law or waste law remedy to get somebody to discontinue the holding of waste and clean up pollution from waste. So in a sense she pulled in the IPC licence issuance, the timing of that, in order to, if you like, exercise a residual discretion under Section 58. Interestingly, she noted, in fact, that the state were not seeking to lift the corporate veil in the case. In other words, they were just looking for the Section 58 order against Irish Ispat Limited in liquidation, if you like. And whereas it's unsurprising at one level that perhaps the state didn't look for fallback orders that we'll come to in a moment in that particular case, given that for the vast majority of the time it was a state-owned company. And of course the shareholders were the various ministers. I mentioned that just by way of introducing the issue of lifting the corporate veil in this particular context. And really at the conclusion of the Section 58 proceedings, Judge Carroll again emphasised, if you like, the primacy of insolvency law over, if you like, well, what I say, principles of a certain normative value coming from environmental law, like the polluter pays principle. In other words, she was asked to apply the polluter pays principle within the Section 58 residual discretion, but her response was as follows. In this case, the polluter, i.e. the company, has no assets. The state is not seeking to lift the corporate veil, which was the approach adopted by Judge O'Sullivan in Wicklow County Council v Fannon. We'll come to that case in a moment. That's from 2002. She said, but most importantly of all, the assets in the hands of the liquidator available for distribution are impressed with a trust for the creditors. There is nothing over for the contributories. The principle of the polluter pays, as far as the company is concerned, cannot be achieved. She said, this is a view supported by Lord Justice Morrity in Re-Celtic Extraction Limited, a UK case from 1999 and the Court of Appeal 2001. There is nothing in the directive to suggest that the polluter pays principle is to be applied to cases where the polluter cannot pay, so as to require that the unsecured creditors of the polluter should pay to the extent of the assets available for distribution among them. A further directive, this is the Waste Framework Directive in Re-Celtic Extraction, it was the Landfill Directive, on waste was cited by the state, this is Judge Carroll again, was cited by the state, is also based on the polluter pays principle, which cannot apply here. For these reasons, I will not exercise the discretion under Section 58 to order the liquidator to expend money which is available for distribution among the creditors in mitigating or remedying pollution in Whole Bowlen. So you note at the outset, she said, the state is not seeking to lift the corporate veil, and we'll come later to whether, in fact, there is any power to do that at all now in this particular context. So moving on to the Section 290 proceedings, I think it's worth just briefly reciting what Section 290 of the Companies Act 1963 provides. Subject to subsections 2 and 5, where any part of the property of a company which is being wound up consists of land of any tenure burdened with onerous covenants or shares or stock in companies, of unprofitable contracts, of other property. So property is the umbrella term, which is unsaleable or not readily saleable by reason of its binding the possessor thereof to the performance of any onerous act, or of the payment of any sum of money, the liquidator of the company, notwithstanding that he has endeavoured to sell or has taken possession of the property or exercised any ownership in relation thereto, may, with leave of the court, disclaim within 12 months or an extended period. And really the issue for the purpose of this talk is really, and it arose in the case, was the IPC licence onerous property or was it saleable property? That's really the issue that arose. And if you like, the position of the state in this case was that an IPC licence is something that you require almost as a privilege to carry on a particular activity. It's not property, or there's no property interests relating to it. It's simply something that sets the conditions under which you can carry on a particular activity. As I say, the state relied on the English case that disclaimed allowed a receiver to disclaim a waste licence in the UK. Ultimately, the court determined this issue without really deciding was the licence of itself property. It really lumped the property and the business and the licence all together. The old Section 91(1) of the EPA Act 1992, which is titled Transfer of the Ownership of an IPC licensed business, states as follows: where a licence or revised licence is granted under this part, the grant of the licence or revised licence shall, except as may otherwise provided by the licence or the revised licence, endure for the benefit of the activity and of all persons interested for the time being therein. So if you like, the licence carries on, or at least back in 2001 or 2003 when this case was decided, 1992 when the original part of the EPA Act was there, like on the transfer of an IPC licensed business, the licence went with the business like, if you like, an intoxicating liquor licence or something of that nature. And in fact, Judge Carroll reviewed all of the legislation and the case law relating to intoxicating liquor licences and transfers of taxi licences and that kind of thing. Ultimately, she felt that Section 290 of the Companies Act didn't talk only about property that was transferable by act only of the parties, but rather by it covered property that could be transferred by operation of the law as well. And based on Section 91(1) of the 92 Act, she felt, if you like, that, well, the licence was property insofar as it was tied to the business and it was tied to the site. I think there's been a statutory change since Irish ISPAT that I think must put a big question mark over that, because as you may be aware now, even when an IPC licensed business is sold, at least when the site is sold or the assets of the business is sold, the licence doesn't go automatically. There must be a separate application to the EPA by the holder and by the proposed transferee, a prior application to the EPA, and that I think is strongly suggestive of the fact that an IPC licence no longer transfers by operation of the law. And again, in relation to the residual discretion which the judge enjoyed under Section 290 of the Companies Act as to whether to disclaim the licence, because it was capable of being disclaimed because it was property. Again, she relied on the timing of the IPC licence in this regard, and the fact that she said the company had operated legally without conditions for many years, which is true if you ignore the pretty poor environmental record it had over the 50 and 60 year period and since the 70s under the Water Pollution Acts and the Air Pollution Acts and its breaches of planning and breaches of the foreshore lease and all of that. But in effect, the critical thing for the judge there was the timing of the IPC licence issue and the position of the other creditors, because she applied the case law, Tempany v Royal Liver Trustees Limited 1984, which said in any consideration of whether you're disclaiming onerous property, you must take into account the position of all parties. And in that regard, the judge said, here there are creditors whose money this is and who would be most affected if there is no disclaimer of the licence. So again, if you like, on one view, a primacy for the environmental or the insolvency law position, really. So I'm just going to move from that, if you like, as a case study of something I'll be coming back to later, the whole issue of financial underwriting for environmental risk and the materialisation of environmental damage. But just, I'll continue with, if you like, the third question I raised at the outset, the other issues like liability of company directors and so on, and position of receivers. And you'll remember the reference to lifting the corporate veil in the Irish ISPAT case. Well, just as regards criminal proceedings, the position is generally clear enough in the sense that most of the main environmental statutes, like the Water Pollution Acts, the Air Pollution Acts, the EPA Acts, the Waste Law and so on, they all really provide that if a criminal offence has been committed, and if that occurs with, and in almost all cases the same formula is used, consent, connivance or through the neglect of officers or directors, and that has a material result on the criminal offence, the corporate criminal offence, then they can be prosecuted as well. Civil liability, the position is somewhat less, well, the corporate veil isn't lifted as often, but there are a couple of well-established scenarios where it can be lifted, and in a summary they are where corporate vehicle is really being used as a fraud, really. There's an abuse of the corporate protection. And the second area is a general set of circumstances to protect the integrity of the court process itself. And that's worth bearing in mind because in 2002, the High Court appeared to move beyond that for the first time in relation to civil liability of directors and found, if you like, a specific environmental law basis for lifting the corporate veil. And the case was the case of Wicklow County Council v Fenton number 2 in 2002. And I think it's still, even though, as I'll mention in a moment, it's really been departed from pretty dramatically very recently, it's worth focusing on just, if you like, to kind of understand the reasoning a bit in the later case, and also, if you like, to kind of demonstrate how these two bodies of law can come into contact. It's one of the cases that arose out of the illegal dumping incidents in Wicklow some years back. And again, we're dealing with sections 57 and 58 of the Waste Management Act of 1996. And the County Council sought orders against the company, the Waste Management Company, from whose property in Dublin the waste had been taken down to Wicklow, against directors of the company and against the landowner in Wicklow and so on. And Judge O'Sullivan, in the case, if you like, traced the development of the polluter pays principle in European policy, environmental policy making and law, right back to a council recommendation in 1975, references to it in the different treaty instruments, and felt that it had certainly been incorporated as a normative principle into the various, he said, all of the waste directives, including the Waste Framework Directive, which he said the Irish Waste Management Act was passed in order to give effect to, or at least partly passed to give effect to the Waste Framework Directive. So in that way he drew a connection between polluter pays principle, Waste Framework Directive and the Waste Management Act. And he basically found that, seeing as the Waste Management Act was passed to give effect, if you like, to the polluter pays principle, it had to be interpreted in a manner consistent with the Waste Framework Directive and to give effect to the polluter pays principle. And on that basis, having, if you like, gone back to the original definition of polluter for the purpose of polluter pays principle, namely somebody who, and this is back to the 1975 recommendation, who directly or indirectly creates the conditions leading to environmental pollution from waste, he found certainly that expression covered the directors of the company in the case before him based on their state of knowledge. And on that basis, he then said, well, if the company can pay for the clean-up to give effect to the polluter pays principle, and namely polluters cover people who indirectly cause it, I can make fallback orders, personal liability orders, directing the directors to clean up. And that really has been the law until a couple of weeks ago in this case of EPA versus Neffen Trading Limited. And that's a decision of Judge Edwards in the High Court, and the date of the decision was the 3rd of March 2011. And I'll just deal with that briefly because I know Alison, who was representing the successful parties in the case, if you like, will be dealing with that in quite a bit of detail. But for present purposes, the position is as follows. They said, Judge Edwards, and it's most unusual for one, if you like, division of the High Court to depart from another decision unless there are very, very clear grounds for doing so, the stare decisis principle, which is really important for the law because it's what gives it its certainty, its predictability, and so on. Basically, they found Fenton was incorrectly decided because Judge Edwards agreed with Judge O'Sullivan up to the point where, yes, the polluter pays principle was incorporated into Irish law, but focusing on the precise wording of sections 57 and 58, or 57 in that case of the Waste Management Act, there was nothing in it, expressly or implicitly, that from an enforcement perspective, that envisaged fallback orders being made against the directors personally. So yes, you could look at sections 57 and 58 to try to interpret them in a manner consistent with the Waste Framework Directive, but you couldn't depart from, if you like, the literal meaning that was very clearly evident in sections 57 and 58. So on that basis, Wicklow County Council v Fenton is no longer represents the law in this regard, if you like, and it gives rise to, at one level, you may say, FM trading is no more than a transposition point that's easily rectified by passing a piece of amended legislation. On the other hand, I think it really brings to centre stage now the issue of whether the relationship, or the legislature here, if you like, are prepared now to grapple for once and for all with, if you like, this uncomfortable interface between environmental law and between corporate stroke insolvency law, and find, if you like, an environmental law basis for lifting the corporate veil to give effect to environmental policy and law. And it'll be very interesting to see what the legislative response, if you like, is to EPA v Nerfin trading, and how quickly, if it comes at all. I've only got a few minutes left, so I'm just going to spend the next few minutes just going very quickly through the slides, just to, if you like, highlight. There's a written paper in the conference pack as well, dealing with all of these issues. The issue of lenders' liability, it's really only arisen as a consideration to any degree in the US in the Fleet Factors case, and you know, the issue there was whether financial management was sufficient to expose lenders to liability by giving the potential to influence, you know, as opposed to direct operational involvement by virtue of being a shadow director or something like that. And there's some comments in the paper as well about shadow directors, and really the relevance of Fleet Factors in the US to Irish environmental laws, if you like, that arising from that whole controversy in the early 90s, a lot of other OECD jurisdictions ended up carving out specific exceptions for secured lenders and banks and so on, in things like definitions of operators in environmental law and so on. And there are some comments in the paper, for example, about, you know, to what extent do the Irish trigger terms in definitions like occupier and person in control for the time being and all of that, to what extent does that sit with the fallout from the Fleet Factors decision in the US? There are some comments in the paper also about mortgagees in possession, and again, you know, you have to be very careful in these situations in this country, because you might find in Ireland that ownership, especially in things like the Planning Acts and in other legislation, can be defined by reference to things like, you know, there'd be a definition of ownership, and it then might exclude mortgagees not in possession, arguably by implication including mortgagees in possession. Interestingly, the Irish Banking Federation made a submission to the Department of the Environment, Heritage and Local Government back in 2007 as part of the regulatory impact analysis public consultation in relation to the transposition of the Environmental Liability Directive, basically saying, you know, be very careful when you come to define operator under the Environmental Liability Directive, because banks, if you like, shouldn't be exposed, and you should be, and the particular response by the department to that particular submission is contained in the paper. Receivers, slightly different considerations apply because, well, depending on the receivership deed, very often, for legal reasons, the receiver can be the agent of the mortgagor or the secured borrower, if you like. And the relevance of that is that, depending again on the receivership deed, there may be no change of occupation, because if in effect he's the agent of the mortgagor or the borrower, if you like, as opposed to, but there are cases in the other direction as well. So the direction that each receivership takes can be important. The receiver can have a very wide remit under a floating charge, for example, over various kinds of assets. And I just refer you to the first section of the paper then, which deals with the whole area of environmental law anticipating a business failure and tracing, if you like, the legislative sources of the entitlement of the EPA to attach increasingly detailed conditions on financial provision and follow-through on financial provision in things like waste licenses and IPPC licenses, the legislative basis for that, and the EPA guidance on that from 2006, and the whole process that's underway under the Environmental Liability Directive at Commission level, but at Member State level as well, with a view down the line, and this isn't going to happen before 2014 when there's an overall review of the Environmental Liability Directive, but at least the process is in train for examining whether, for all of the Annex 3 activities, or most of them at least, there'll be some exceptions for some de minimis exceptions, a system of mandatory, harmonised across the EU27, mandatory financial underwriting or security, covering things like, obviously, insurance, remediation insurance, escrow accounts, cash deposits, accumulating cash funds, when to use them and in what scenarios to use them and what mix of them to use, and so on. But we're some way off that, for example, because the Environmental Liability Directive, as you may know, envisages things like, replacing salt marsh or habitats from one location to another, even that kind of compensatory remediation. And for the very most part, that type of scenario is outside most of the environmental insurances that are still available, but the position is changing. So I think the questions are being taken at the end of the session, and thank you for your attention. I'd be very happy to answer any questions you have.